Alifa. Then I Google me.
Yellow, blue, green.
Okay. I think this cameras have done something to my thing.
Amadu kana kai.
Yeah, Amadu na kai yo. Ba mu jin ka.
I think I may have to.
Kana zikiri ne.
Yana center na man.
A kana masallaci kana zikiri. A yaje jakuni na. Me za ka jakuni? Me kudi ne ni.
Na miu kai na ne saboda ba ni.
We go you now.
Okay.
Yeah, we go you now.
Because
Opele ka sa fulla kamar sarkin wanga da mango.
Na kare sallah no kenan.
Oh, Magribi ko.
Magribi.
Ya Magribi.
Kudi na yau.
Don waraka dai raka sallar asar dai ai dole tambaye ka ko Magribi ne ka san da gomba waye.
Na fila.
Ka san da gomba su suna na fila bayan na.
Ni kwana ma ke ji na chale.
Na fila yi.
An gaji. An gaji.
Uncle Emiki me. Dollar come.
Wisdom is your setup ready?
Give me a minute.
Okay.
In ya fara mun ya mun mute ai.
Yeah. You are muted. Yep. Yeah, you okay now?
Okay. Sorry, I usually go to the office, but I'm trying to do it from
home
outside the office. I hope it's okay.
Okay, all right, that's good. So thank you very much and welcome to once again Legal Hour with Lawyer Wisdom of Wismart Solicitors based at Dalston in London. So this is our usual monthly legal hour session, which is usually free of charge out of his own generosity to his Ghanaian community in the UK. So we are really pleased to have Lawyer Wisdom with us again for this month's session. That is the month of July 2021. So as usual, we run for about 30 minutes of lecture or 40 minutes of lecture, and then to be followed by question and answer sessions. Please, if you're able to ask your question live, the Wisdom is happy to answer. If you're not able to do that, you can always put it in a text to me, and then I'll read it out and then for a response. So without much ado, Lawyer Wisdom, once again, you're welcome to Zumunta Association UK. This is live on Zoom and then SARKI TV on YouTube. Thank you.
Thank you. I am on TV, but my background is not very nice. I'm sorry, forgive me.
That's fine.
Okay. Hello, everyone. Good evening, and I hope we are all doing well.
Yes, we are, by His grace.
We thank God. We thank God for His grace and mercies. Yes. That another month has gone and come, and we are still here. We are still alive.
Yeah.
We are in the midst of the living.
That's
yes.
It.
Today, I just want us to. I just give a few updates, and then maybe if there are some questions, I would go through it.
Okay.
So we are all aware that the EU settlement scheme is officially over, which is it ended on the 30th of June 2021. However, the Home Office says if there was anybody who could not apply before the 30th of June, they are still able to apply for the settlement scheme. But there has to be a good reason why that person couldn't apply before the 30th of June. We have to give a reason why they couldn't apply before the 30th of June. So they themselves have given us some reasons why a person could possibly not have applied. And then based on that, you select one of the reasons and then you proceed. I'll quickly just run through some of the reasons why a person can apply, based on which a person can apply if they didn't apply before the 30th of June 2021. Number one, they have put it in about 5 categories: children, disability, practical reasons, and immigration status reasons. The first one is children. If there was a child in care, and because they were in care, they couldn't apply. Now that it is past the 30th of June, they can still apply. It provided you can show that the child was in care at the time of the deadline. So that is a possibility. They can apply now. They can still apply now. And the child should be given the 5 years pre-settled status or indefinite leave if there is evidence as to why they could not apply before the 30th of June. The next one is if the child was in the care of the local authority, council. Maybe there was an issue with the parents having disagreements as to child care and issues. There's an issue of domestic issue, and the child is in the care of the council, and the council did not apply for that child. Even though it is past the 30th of June, the child or the application can still be made for that child. And then the next one is we come to the section where it talks about disability and ill health. If for any reason at all a person was not well, they were not well, they were seriously unwell, and as a result of that, they couldn't apply, they can still apply now. That it is, although it is past the 30th of June, we can still apply for that person to get their limited leave to remain, limited leave, or their is either the limited leave or the indefinite leave to remain. And also it says if for any reason at all the person was unable to apply because they have some mental or physical disability, that is also a reason which they can base their application on. That look, I had a problem health-wise and I was not able to apply before the 30th of June. Therefore, I'm not in the position to apply. You just tick that box and then you go on with the application. The next one is I was unable to apply by deadline due to my care and support needs. Assuming it's an EU national or a family member of the EU national who was in care, needed care. They needed somebody to care for them, somebody to take care of their feeding, their maintenance, their physical care, and they themselves couldn't do it. You can still apply if that is the case. You only have to take the reason that they were in care. That is why they couldn't apply at the time. So that is another reason. And then we go to the practical or compassionate reasons. Now, if you look at the practical and compassionate reasons, the reasons they have there are quite a few. One is I was unable to apply by the deadline for reasons connected to modern slavery. Assuming a husband and wife are in the UK, husband is an EU national, wife is a non-EU national, but wife is being treated more or less like a slave. The husband has control over the wife's affairs, total control. If the woman works, the money has to go into the man's account. The man says, if your money doesn't come into my account, I'm not going to give you my passport or my passcode or my reference number to apply. If that was the case, the woman can now apply and say, look, I am more or less like a victim of slavery because my affairs were being controlled, totally controlled by my spouse. He wouldn't give this to me, etc., etc. Now that I'm able to get it, that is why I'm applying out of time. Or if there's somebody who is a victim of domestic violence, again, the person could apply now to say, look, I was a victim of domestic violence. My husband didn't give it to me. My husband didn't give me his card. He didn't give me his passport. He didn't give me the documents, and that is why I couldn't apply before the 30th of June. Now that I have the documents, I now want to make the application. The Home Office says that person can also apply. Another reason is, in fact, I like this reason most. He says, I am not aware that I should have applied. In other words, they didn't know at all that they should have applied. They don't listen to radio, they don't watch TV, and so they did not know. So interestingly, the Home Office themselves have put that reason there. So you just take that one. I was not aware that I should have applied. And so from there, you just move on. Now, if you say you are not aware, you don't have to prove with any evidence because if you say you were in care, you need to provide evidence. If you say you were in the hospital, you need to provide evidence. If you say you were not aware, you are not aware. There's no evidence to provide. So you just move on. I think that is the best of all the reasons that you can possibly take. And then there's another one which says, I do not have the IT skills. I don't know how to use the computer. If I see the mouse, I think the mouse will catch me. So I didn't know how to use the computer. I have no IT skills, and that is why I could not apply. That is also one good reason why you can apply now, that even though it is outside the normal time to apply. I printed the reasons out. There's another one which says I was unable to apply due to COVID-related issues. Well, if the person also had COVID-19 and was probably in the hospital, or even not in the hospital, but they were not strong enough to even apply, that is also a reason. And one is the person was in prison. If for any reason at all the EU national or their spouse was in prison and they could not apply, then now that they are possibly out of prison, they can also apply for the settlement scheme or the pre-settled status. Another one is very interesting is I did not know, I have lived in the UK for so long that I did not know that I had to apply. There are EU nationals who have lived in this country for 15, 20, 25 years. Such persons, because they've lived here so long, they never knew that, or they didn't know that they had to also apply. Some of them had permanent residence card and they thought that was the end of it. But they were supposed to have applied, but they didn't know. That is also another good reason why you can take that. I've lived here for so long, I didn't know that I also had to apply. That is also another good reason. And a few other reasons which are very practical is immigration reasons. It says my biometric residence card expired after the deadline and I was not aware I needed to apply. Maybe some people had the biometric residence card, the 5 years or the indefinite permanent residence card. It expired after the 30th. They didn't know they had to apply before it expired. And so now that they got to know, they can also apply. Then one other very, very practical reason is I am applying before the expiry of my limited leave to enter or remain under another route. Maybe the person had another 2.5 years route or another route altogether, but they should also have applied. They didn't. They can also apply now. But the best reasons for me so far is the one I mentioned earlier, that I did not know that I had to apply. I don't listen to radio, I don't watch television, and there I just did not know. And then they also said if there are any other practical reasons, example, my passport expired and I didn't have a valid passport. My passport was at the Ghana High Commission. I sent it for renewal. And because I need to have a valid passport before I can apply, my passport was at the Ghana High Commission. I did not have a passport. I have now received it and I am now applying. Now, if you select that reason, they want to see when the passport was issued. If the passport was issued way, way, way before 30th of June, then you cannot use that reason as a good one. But if the passport was issued after June, then that is a very good reason why you couldn't apply before the 30th of June, because your passport was at the Ghana High Commission for renewal. So there's a wide range of reasons based on which a person can apply. Although officially the limited leave to remain or the pre-settled status application is expired, you can still proceed with the application and just select one of the reasons they themselves have given. You didn't provide the reasons, they themselves have provided the reasons. Select one that suits you and then you can move on with the application. They will give it to you because this is what they said. They said they want to look at things practically and also very liberally. They're not going to use very strict rules to apply to these applications. So that is very, very good news for me. Now, assuming somebody just came to the UK, an EU national, they just came to the UK, can they apply for the settled or pre-settled status? No, unless maybe whilst they were here or whilst they were away, they came here, had an NI, then had some proof of address, and the proof of address was before the 30th of the 31st of December last year. So if you are approved between July 2020 to December 2020, yes, in that case, you can still apply for the settled or the pre-settled status. And say that is how it is. Briefly update. Now, a second update I want to give out is there is this case. I think I mentioned it. I don't know if I mentioned it the last time. The case of Akinsanya. Yes, I mentioned the case of Akinsanya.
Yeah, yes, you did. Yeah.
I did. Okay, I'll just go over it again briefly. Now, what it means is if you are a carer of a British citizen child, your child is a British citizen, and the child has been British for 5 years. In that case, if you can prove that if you leave the UK, the child will also leave, then the case of Akinsanya says you can apply for indefinite leave to remain straight away. However, the Home Office is challenging the decision. We suspect that the final decision of the court will come out somewhere, maybe sometime next month or the month after. Court cases, you can't be too sure with dates, but we hope that it shouldn't take too long, then the decision will come out. If and when the decision comes out and the court says we can apply, then all the people who are on 5 years and they are carers of British citizen children or child can go straight away for indefinite leave. So assuming somebody has 2.5 years and their child has been a British for more than 5 years, and they had 2.5 and 2.5 years, such a person, if the decision goes well in our favor, then they don't have to go for another 2.5 and 2.5 again to make it a total of 10 years. They can go straight away for indefinite leave to remain. But we have to wait until the outcome of the court decision. A lot of people are applying. They just want to take it there and wait in the queue. Once the decision comes, they are ready in the queue, and then the decision will be made. Now, if for any reason at all, the Home Office wins the case, then what will happen is they will just return your documentations to you, and then you can still carry on with the 2.5. But I have a very strong suspicion that reading the case and how the judge wrote it, the judge at the court, the High Court wrote it, I have a very strong, conviction that we might just pull this one through. So let's just wait and see how it goes. If you need to travel or you need to look for work, I would not advise you to apply because you will have to send your passport to the Home Office. Your passport will get locked at the Home Office. If you need to travel, you can't travel. In that case, I would say let's hang on until the case comes out. Probably after you've come back from your holiday, then we can make that application. Then there is a recent case law which also came out, and it's about a gentleman who is a Pakistani but claims he's from another country. Now that man used a lot of deception in making applications. Ultimately, he got his indefinite leave to remain. But later, the Home Office found out when he completed another form, he put his actual nationality on that form, whereas he was saying he was from another country all this while. Now, when they found out that he was lying all this while, the Home Office revoked, they canceled his indefinite leave to remain, because the Home Office argument is, we gave it to you because we believed you came from country A and the circumstances prevailing in country A. That was why we gave you the indefinite leave to remain. But now that we have seen that you come from country B, it means that you use deception. If we had known that you were from country B, there was no way we were going to give you the indefinite leave to remain. So they have to cancel it. They canceled it. But what saved him was he has children who are British citizens. So somebody who had indefinite leave, now he's going to go back on the 2.5 and 2.5 and 2.5 and 2.5 route. At least he had children. Otherwise, he would have had absolutely nothing. So the point the Home Office made is this: if you use a historical deception, if you use historical deception, if a person lies and lied and lied and lied in all the applications to a point they got indefinite, and then they finally find out that all those applications you were making was based on a lie, they can still cancel your indefinite leave to remain. So my advice is, let your information be consistent. Let your information be consistent. If you are from Afghanistan, please remain an Afghan throughout your life. If you are from Pakistan, remain a Pakistani national. Don't be a Pakistani today and an Afghan tomorrow. If they realize that there is deception and switching from here to here, they can easily revoke or cancel your indefinite leave to remain. If you are not fortunate like this gentleman, you have nothing to base your future application on, you may have to leave the UK. And I don't think any of us want to leave the UK. I mean, by virtue of the way we are enjoying in the UK, I don't think anybody wants to leave the UK. It's hard, but it's also nice. When you walk out of your house, there is a bus. When you go to the train station, there's a train. There is no light off. Since I came to this country, I haven't had light off before. Water is always flowing. I mean, these are the things why, even though we know it's hard, but we still remain here. It is not like a certain country I know where every other day there is power off or there is water not flowing. I will not mention any country for security reasons. So yes. All right. So that is a bit by way of update. Now, what I also want to talk about today is quite something we all know about, but I just want to mention it a bit. Although the topic is, how can you still rely on the EU law? How can a person still rely on the EU law? Now, before the change, there's the EU law is called Immigration EEA Regulation 2016. Immigration EEA Regulation, initially it was Immigration EEA Regulation 2006. And then after 10 years, it became Immigration EEA Regulation 2016. And now, because of Brexit, it has been transposed, it changed into UK law, and it is now called Appendix EU. Appendix EU. So it is just the same EU laws that they have lifted, and they have come to put it under the UK immigration laws. However, it is more or less the same EU laws. They've just changed the name to some extent, Appendix EU. Now, under what circumstances can a person still apply under this Appendix EU? I'll just mention a few. Then if there are questions, I'll take them. Number one, if you married to an EU national before the 31st of December last year, you can still depend on the EU laws. If the marriage was before the 31st of December 2020, you can still use the Appendix EU or the EU law. Example, I am in the UK. I haven't been to Ghana. My family is in the UK. I got them to contract the marriage on my behalf because the woman and I are here. But they did a customary marriage on my behalf. They obtained the certificate on my behalf. And the date of the marriage is the 29th of November or the 1st of December or even the 25th of December. That is before the 31st of December. I can still rely on the EU law and I will get my 5 years to be in the UK. If I married after from the 1st of January this year, I cannot use the EU law. Even though I am married to the EU national, they will still use the UK law to determine my application. Although I marry an EU national, once the date of the marriage is from the 1st of January, I cannot use the EU law. So if a person wants to rely on the EU law, then their marriage should have been dated before the 31st of December last year. So that is one. Number two, another aspect or another category in which you can rely on a EU law is if you are an EU national and you have children who are outside, you can still bring your children into the UK still based on the EU law. Your children can still come to the UK based on the EU law. So that is that aspect. Your children from 0 to 21, you don't have to show anything, whether you're looking after them or not, it's not a problem. All you need to show is that they are your kids. If they are more than 21, then you have to show that you are looking after them or you are responsible for them or they are dependent on you. They can also still come based on the EU law. Or you are not an EU national, but you marry an EU national. If that is the case, your children, your children's children can all also come based on the EU law. So, assuming that I am married to an EU national, all my children can also come as family members of the EU national. My parents, my grandparents, they can all also come as family members of the EU national. Even though we have left the EU, my parents, my grandparents, my great-great-grandparents, provided they are alive, they all come within the same line of EU law. They can still come to join my spouse and myself here if I am married to an EU national. So I've talked about the children, I've talked about the grandchildren, I've talked about the parents, talked about the grandparents, provided they are alive, they can all come to join the family here in the UK as family members of the EU national. Even though we are officially out of the EU, the provision is still there. Another aspect, there is a case called the case of PG and VG, the case of PG versus VG. That is the case based on which grandchildren are regarded as family members and they can also come to the UK to be with the EU national. Another aspect is if you retain the right of residence, something we call retain right of residence. Retain right of residence means if you go to the old law, it is called paragraph, no, it's called appendix, no, not appendix, it's paragraph 276, that is under the UK law. It is regulation 15(1)(f), and we've got regulation 10(5) and 10(6) of the old law. We have regulation 15(1)(f), and also regulation 10(5) and 10(6) under the 2016 regulation. Now it's been put under the appendix EU, and it is put under appendix EU, we call it appendix EU 1, annex 1, which is the definition. Now, a person who has retained their right of residence is, assuming, I use myself as an example again, assuming I am married to an EU national, the marriage lasted for 3 years, and then I start divorce. I'm married, the marriage has lasted for 3 years, 3 years from the date on the marriage certificate, and then I start divorce after 3 years, maybe 1 day or 2 days or 1 week after the 3 years. And then I can prove that the EU national and myself, we have both lived in the UK for 1 year. So number one is the marriage should last for 3 years before I start the divorce. If I start the divorce before 3 years, I can't get anything. My leave is when my leave expires or it runs out. That's it. I have shortchanged myself. So I just have to be patient until my residence card is 5 years old. The marriage. We are looking on the dates on the marriage certificate. We are looking on the dates on the marriage certificate. If it is 3 years, then after the 3 years, I start the divorce proceedings. That is number one. Number two, I have to prove with evidence that the EU national and myself, we have both lived in the UK for at least 1 year. During that 3 years, I have to have evidence to show that we've lived in the UK for at least 1 year. Then the next thing is I have to show that on the date of the divorce, the EU national was in the UK and was working. she must be a qualified person. When we say a qualified person, we are talking about somebody who is a worker, who was a job seeker, who was self-sufficient, who was self-employed, or he was a student who has comprehensive medical insurance. Now, if I can prove that my EU national was a qualified person on the date of divorce or on the date that I started the divorce proceedings, and then after the divorce, I will continue with working. I will continue with working. Excuse me. I will continue working continuously for 5 years. I have retained the right of residence. So there are 4 things. Number 1, the marriage must be 3 years before I start the divorce. Number 2, both of us should have lived in the UK for 1 year. Number 3, on the date I start the divorce, the EU national should be in the UK as a qualified person. And if I say a qualified person, worker, self-employed, self-sufficient, student, or job seeker. And number 4, I should be working from the date of the divorce continuously. It's like the EU national has handed the baton over to me and I have to continue with the working. If I meet these 4 requirements, I have retained the right of residence. I can still rely on the EU national, the EU law again, and get my indefinite leave to remain. So that is, even though I am divorced, I can still base my application on the EU law and get my indefinite leave. That is a retained right of residence. Another category is if my wife is an EU national, the relationship is broken, she has moved away, the child we have a child, and the child lives with me. Because of my child, I am also regarded as a person who has retained the right of residence. Based on the child who is an EU national that is living with me, I can also still apply based on the EU law. Another category is I marry an EU national, and unfortunately, she passes away. I was living with her 1 year before she passes away. I have retained the right of residence. I can apply immediately for the pre-settled status. If the marriage lasted for 2 years before she passed away, I can go away. I can go straight away for indefinite leave to remain. So these are the circumstances under which we can still continue to rely on the EU law, which is now called Appendix EU. Another very, very important area we can rely on still is domestic violence. If I am a victim of domestic violence or domestic abuse, now, somebody will say, oh, how can a man be a victim of domestic abuse? It happens all the times. The women beat us, only that we don't talk. Because you don't want to go and talk, and your friends will be laughing at you. Your wife has been beating you, so we keep quiet and suffer. So if you're a victim of domestic abuse and you have evidence, if there is no evidence, you can do nothing. There is medical reports, there is police report, or there's an organization that can produce a letter for you to say that, yes, we have you on record as being a victim of domestic violence. You can also, based on that, still under the EU law, you can get your indefinite leave to remain. Now, if I say domestic abuse or domestic violence, what am I talking about? We have several aspects of domestic violence. We have psychological, we have emotional, we have financial, we have sexual, and then we have physical. So mostly when we talk about domestic abuse, we only think about the physical one, that maybe she has hit you or you have hit her or something. That is only one aspect of domestic abuse. There are other aspects. Sexual is also a domestic abuse. So don't ask me if for 6 months she says no, is that a domestic abuse? That is, as for that one, we can talk about that later. So it's all financial abuse. The man says, if you don't put your money, if your money doesn't come into my account, or after every month you don't put £1,000 in the account, I'm not going to support your application. Or that has subjected the woman or the man to all kinds of torture. That is also abuse. So when we talk about domestic abuse, it's psychological, sometimes psychological, it's emotional, it is financial. Now, sometimes the psychological ones is even more torturing than the physical one. Sometimes somebody will say something it hurts you more than even if they had put their hands on you. See, this is all parts of domestic abuse, but you must have the record to show that the relationship broke down because of the domestic abuse. And once you have the evidence, police report, medical report, letters from independent social organizations, then you can apply still under the EU law as a person who has retained the right of residence. So generally, I have mentioned a wide range of areas that a person can still benefit under the EU law. I talk about marriage, I talk about divorce, retention of rights, I talk about being in custody of the EU national's child, I've talked about domestic abuse, I've talked about retention of rights. I've mentioned that being a child, being a stepchild of the EU national, being a grandparent, a parent, all these categories are still available that we can make application under the provision of the EU laws. So although it says it is over, it is not totally over. There are still aspects that we can make application. I will just pause here and solicit for any questions that might be of importance, and I can respond to it.
All right, thank you very much. Thank you very much, Mr. Wisdom. To all listeners, please, we are at a question and answer session. I have a very lengthy question here, maybe to start with, and then thereafter, the audience could also come in with their questions. I'm reading it out as it's written to me.
All right.
It's a woman married to an EU national, and she had a baby with a different person. And took the baby to Ghana. The girl is 10 years. On the birth certificate, it's a different person's name. That's a different father's name on the birth certificate. So in case the woman divorces her EU husband before applying for her daughter to join her, sorry, the woman has not divorced yet, but can she apply for her daughter to join her here before the divorce?
That is possible, but that is very dangerous.
Okay.
The reason why I say it is dangerous is, now why would I be married to a lady and then another man's name will be on our child's birth certificate? Yeah. So that brings the marriage into question, whether it is a genuine marriage or not.
No. Okay.
So what I would advise in this case is she shouldn't be in a hurry to bring the child. God willing, when she obtains her indefinite leave to remain, and then there is a divorce, the divorce is possibly because the woman had an affair and the woman got to know. That is why there was somebody else's name on the birth certificate. So that is why the man divorced the woman. Now that she now has an indefinite leave to remain, she can apply for British passport, to apply to register the child as a British citizen automatically. The child becomes a British citizen. So before the child arrives in this country, the child has their British passport to come with. Not before the divorce or not before the indefinite. It is quite a dangerous territory.
Yeah, she's got the indefinite leave to remain anyway.
Well, in that case, I would say after the divorce, she can then apply for the child. She can just register the child as a British citizen and then bring the child. Yes.
All right. Oh, thank you very much. To our listeners, is there any other question coming from anyone, please? Whilst we wait for further questions, maybe Lawyer Wisdom, is it right for the Home Office to ask an EU family member to pay for their indefinite card to be issued? Someone has been asked to pay £248.
They should not ask you to pay for the card, but they can ask you to pay for the appointment.
Okay.
Yes, what happens is there's a fee of it's £112 usually. Okay. When you make the application itself for the residence card or the indefinite leave card, they tell you there is no fee to pay. After you've been granted and you want to change the card from the old card to the new card, you pay for the appointment, which is £112. But if it is just for the card, then that is not right for them to pay.
Okay.
However, there is another card. I am sure the money you mentioned tells me it's another card. There's something we call Form NTL, no time limit. That is a person who has indefinite leave in the passport or on the paper, and they want to switch it to the card. They are paying £224. So maybe that is the one the person is doing. Yeah.
Probably that fits the person's situation.
Yes.
Okay. All right. Thank you very much. Alaji Bule, have you got a question, please?
Oh, yes. Good evening, sir.
Good evening, my brother. How are you?
Yeah. Brother Wisdom.
Yes, sir.
I have a son.
Or you can speak God to him. He understands God.
I have a son born here.
Okay.
I'm a German national.
All right.
And then he has a German passport.
Right.
But I want to apply British passport for him.
Yes.
Which formula I have to follow, which form I have to fill?
Okay.
Because I think I have to naturalize him.
Yes. No, it depends. It depends. If you were in the UK and you worked for more than 5 years before the child was born, if you work for 5 years before the child was born, the child is automatically a British citizen. If you worked 5 years before the child was born, that child is automatically a British citizen under Section 11 of the British Nationality Act of 1981.
Okay.
But if the child was born before you became 5 years in the UK, then you have to register the child as a British citizen under Section 13 of the British Nationality Act 1981. Now, if the child is automatically British, then you just have to pick the form at the post office and complete the form, or you can do it online, which is quicker, easy, online British passport form for the child. But if you have to register the child, because let's say you were 3 years in the UK and the child was born, now you have your indefinite, you have to register the child. The form is called Form AMN1. M for mother, N for November, 1. MN1. So I'll ask you a question, sir. Were you 5 years in the UK before your child was born?
Yes, no, because I tried to apply, right? And then they send me a query that I should prove, although I've even sent, but some of the people's miss from job center and HMRC.
Okay,
I called the job center.
I'll ask the question again. I'll ask the question again. Were you 5 years before the child was born?
Yes.
Yes, sir.
Okay. Yes, but the reason why I'm saying so, I just want you to understand. I even tried to apply, right? I sent all the documents.
Right.
I worked before I started my self-employed.
Okay.
So I sent the P45 or P60, and then I send some of my self-employed tax return.
Right.
And then there are some gaps. So those gaps, they asked me to prove it.
How much gaps? Is it more than 6 months?
Unless I look back.
Yes. And if the gap, 1 minute, please. If the gap is more than 6 months, that breaks your 5 years continuous residence.
Okay.
If the gap is more than 6 months in a particular year.
Okay.
So, but go on, sir.
I don't know, but I didn't. Now you are telling me something different because you have the idea. So yeah. I asked the job center. They couldn't. They give some. They didn't give some. They say some of the documents missing.
Right.
Right. Yeah. This what they said. The letter is there or something. That is what they have for me. Okay. And then I asked HMRC also. I think they sent theirs. So I add all and send it back. Still, they are requesting other things. Then I say, okay, no problem. I will register him. Then I asked them which way I have to follow. And then the man said, I can register him, or I can go and ask a solicitor.
Right.
So that he can show me the form and everything.
Okay, that's fine.
Even the first one is 10 years, and then the second one is about 7. But the second one, that is the one I try to apply
Register. For. Okay. So what I would advise you to do is, if you have the evidence from the HMRC, just draw a straight line and see where the gaps are. Let's say 2014, you have evidence, 2015, you have the 2016 P60, 2017 P60, 2018, maybe there is a gap. Maybe you became self-employed. Then you can use the assessment, your self-assessment to fill in that gap. And then you continue from there. As long as it was, or it is 5 years continuous before the child was born, then the child should be a British citizen automatically. You don't have to go and pay that £1,012. But what you can also do is you can do your own letter, cover letter, and do number 1, from this time to this time I worked. Number 2, from this time to this time I worked. Number 3, this time to this time I worked. Number 4, this time to this time I was self-employed. 5, this time to this time I was self-employed. 6, this time to this time I worked. Now the child was born after this period. So sometimes if you put it out there clearly for them to see on the paper, it's easier for them to make the decision. But if you just send everything, sometimes the caseworkers may not really have their head around it to know what fits where. They just bring everything back to you that you haven't provided enough evidence. But it appears to me that you should have met it, but you only need to put the paper right. Just arrange it nicely, and I'm sure, and make a note. It should be. I think the child should be fine.
Okay.
But do you have indefinite leave yourself?
Yes.
All right. So worst case scenario, if they are still saying no, then you only have to register the child under paragraph 1.3 of the Immigration of the British Nationality Act 1981. Like I said, in that case, you would have to pay the £1,012.
If I register him under the
Section 1.3, you pay £1,012.
Okay, that is the form is MN1.
That's correct, sir.
Okay.
Mm-hmm.
Okay.
Right.
Thank you.
You're welcome, sir. Thanks.
All right. Thanks very much. Thanks so much. Senior Sule, have you got a question, please?
Hello?
Have you got a question?
Assalamu alaikum.
Wa alaikum salam. Have you got a question, please?
Not a question. I'm not so late today.
Okay
then. Mr. Wisdom.
Yes, sir.
Good evening.
Good evening. How are you doing?
Me call to the vernacular there. We call it tree.
You young boy.
Yeah. Okay. Yeah. British, no.
Yes.
Say, per se, young koda, and now your bar, now be a say adopting a fan bar. Send a quite be never fast.
You say, Abufrani Mammy bis Abufrani Mammy Wahe.
According to Mammy, infant say or fear or Ghana.
Okay. Say, according Mammy wa Ghana, and no, over using UK Mrano, and no, your friend of paragraph 297 of the immigration rules. And no, adding, because Ombaka say, Abufrani Mammy, bet me a sheno, and any mammy na air sheno. And non see, review why your friend of sole responsibility. As a sort of said, wouldn't Usha Abufrani Didier, woman in the sika, the school come, the hospital come, the entire shame, be a order, ni bibia, una we bibia, as so just a name, and yet involved, Abufrani life at all. But a yana is so difficult, say, Abufra on any mammy with the same country, no, Ubeka mammy, and yet involved in the child's life. Yes, it is possible, but the requirements are a lot. It is possible, but the requirements are a lot. And only a friend is so responsibility. And the young no, Uba, yeah, you more letters. Send your person but letters no. Letters no, yeah, but your template to her. Would you come school no? School number say I, Mr. So and so, on any above way, papa. I know grand ne fresh school no, a pair school marble, a pair admission marble frano. A year of fresh school no, no, I check you on above frano say, how is the attendance and any performance echo? Say your any issues be any papa ni discuss it. Papa ni bagan and swa, a year of Baba's trouble frano school. So these are the things that Ning number chro salad. Yeah, but the amount to the amount more so now they are two on my letterhead no so. Not hospital and our clinic. Also draw letter say papa way on never free papa a year of free. Sabo free in tiapo no about hospital poor. Yeah, your friendly papa, yenina kasa ansana ya money treatment. Ni papa with chest canning salad and so you will be or edimawa because who got catching so here letter send but yeah, the mawa now the maoma they don't know what to do. They'll put it on their letterhead on one sign. They make changes to it with their brain. So long and short, they say it is possible. Obi bakaso say me manisika, and yes, you can kwana shabufra baby. Who manisika mom now? So who makes the decisions? That's the main thing. Who makes the major decisions in the child's life? School, health, welfare, home condition. The person who makes the major decision is the person who has the responsibility. So you have to show that you make those decisions, and you can only show with letters from these institutions. With that, then certainly you can apply. There is another section called paragraph 297ID. The D stands for if the child's other parent is dead. If that is the case, you need to provide a death certificate. And the death certificate will show that Abufrey Mami, Efimunti, Abufrani Ding na, I want the birth certificate, no so no. And then the Mami Ding na birth certificate, no so. So Mami didn't necessarily call death certificate, no so. Want to be confirm Memuna and to birth certificate, no so. Then confirm Zainab and to death certificate, no so. These are two different people. So they are. The name on the child's birth certificate, the mother's name on the child's birth certificate must be the mother's name on the death certificate. So, here, and no, that's so responsibility now make it does not apply because Abu Friend it is only common sense to everybody say ni papa na and yes, these are the circumstances. So responsibility or when one parent is dead, it is possible to bring that child to the UK.
Okay, me that say I'm funny say no say Mrs. Taba and any papa from the dada but responsibility na me na me sure one na school ye. This is children na me say me funny ba but me na me bia.
Okay. So
why be na me faso because
I know they just say who adopt abofrano.
Very good.
Because onye who biological.
Yeah.
And who adopt abofrano. Who adopting na wababa ye wuba.
Yeah.
Who kura British citizenship who adopting we are abofrano benya British citizenship because wababa ye wuba. So adoption, yes. And also it's a lengthy process. Menim say what here Victoria Clemby case be in the UK. Yes, yes. A bit more adopted Mofrabi, they are bad, they were so mean to them, they abused them, and it was in the news. So say no, the councils want to be involved in every foreign adoption. They want to be sure that you are going through the right procedure. The child comes to the UK, they have their eye on the child, they are monitoring, they're ensuring that the child is properly cared for. So you have to start the adoption by contacting the adoption agency within your council. They will go through the process. You go for application, you apply to the Department of Education. They'll give you a certificate of eligibility to adopt, and then they'll do your home assessment, home pack assessment. They'll come to your house, they'll assess your work, assess your medical condition, check your home condition, how many rooms you have, if there's going to be enough room. They'll do all this and prepare the home pack assessment. Once you have that, then you can then contact the social department, social welfare in Ghana. You get a report from them. You also have to identify the child. You have to be in Ghana for 3 months with the child to get to know the child for 3 months in Ghana. Once all of this is over, the court will then give you the adoption certificate that you can apply to bring the child to the UK as your own child this time.
Wow.
Let me
Thanks
just
very
say,
much.
I'll come to see you.
All right then.
All right,
Yes.
I'll come to
But-
see you so that we
yeah.
sit together. Yeah, because even
Yeah.
my wife also, she wanted to bring a daughter also. So I'll come
Okay.
there. All right.
You should be ready
That's
to.
it.
You should-
Yeah.
yeah, Nas, you should be ready to make available the cost of around 15 to 20,000 pounds. Not for me, no, but for the for the council going through the procedure and all those things, their report and everything. That is how much they charge in totality for all these things. So it's a lot of money, but I mean the child's life is more than 20,000 pounds. So
That's right.
Physical money. Some way they have to Ghana.
Yeah. Anyway, but that is what the procedure is now.
Yes.
No problem.
Yeah.
Yeah, that's it.
Yo, Bramian Tinasenka, all right. Said not many about who a man in Sasu or Kamu and a man in Sasu.
Yeah, Amadou. Yeah, could unmute Kanka Kaitambayan.
Hello, Wisdom.
Hello, Amadou, how are you?
I'm okay. Oh,
Good,
It's,
good. Hey, yeah.
okay. What am I making kind of fantina is a clear.
Okay.
For instance, if like you have a leave to remain,
Mm-hmm.
yeah, under EU.
Yes.
Now, what basically now or a leave remain card, you know, na uba. Oh, after 5 years now we are indefinite, you know, na uba. Sabanu only how or Ghana any status near there.
The status no one to send you one. So what worry you near now?
And what were you ni mad divorce?
Okay. So yeah, someone
Who divorce and son we are
so who divorcee and son away application now. Abofrano still no Oyagana name.
okay.
Oyagana name. Na nibanunso almost the UK law and a share almost EU law and share because remember say EU nina nanka one is so no one name the subium and to say normally UK law and a share sa application. But a idea anka one EU no does a war and the anka almost the UK EU law no and a share application.
Some more what than some boy you see EU law.
That's it. That's it. I know you're more straightforward.
Oh,
Yes.
okay.
Okay. All right. Thank you
Okay.
very much.
But so far as a mad divorce no and son who banu there a UK law.
A UK law, yes. And no, but the evidence, the law of the paragraph 297 make and appendix FMEC-C 1.1 onwards, no, and because and what under UK law and they under EU law bill.
Oh, sorry, he's muted.
Yeah, okay.
Yeah. Amadou, you are muted. Is there any further questions or your questions are all answered? Okay, so we got a thumbs up. That means he's good.
Okay.
So I think we've gone past the hour mark, and I don't think we've got further questions coming through. So I will say a big thank you to you once again, Lawyer Wisdom, for being with us. We will continue to disseminate, to send the information out in terms of your contact and then location for people to make contact. So we really, really appreciate your time. We appreciate that. And then hopefully we'll regroup again towards the end of August.
Thank you.
Let's say, inshallah.
Yeah, God bless you. Thank you so
All
much.
right. Thank you very
Thank
much.
you.
Have
Oh,
a
yes.
blessed evening.
Next month, I think, God willing, we are observing a few problems now. People who have the EU residence card and then they travel when they are coming back. We are observing some few problems. So next month, God willing, just remind me that I can touch on what preparations they have to do before they travel when you have the EU residence card or the limited leave to remain.
Okay.
Thank you, sir.
All right.
Yeah.
All right.
Thank
Thanks
you.
very much. Thanks.
You're welcome.
All right.
Okay.
Bye.
Enjoy the rest of the weekend.
Same to you.
Bye.
Bye. America sorry kazo akwai magana ne.
Chairman,
Na'am.
akwai da lawyer na man sallah ba.
Kai ka kai mai don ka san mun baka address ofisin shi.
No, ni na kai mai na personal.
Da mun baka na zumunta ka